Hey everyone. So last week I just completed a week of jury service. I sat on a jury in a federal case, a civil trial, not a criminal one, and it was a sex discrimination case. The plaintiff, whose name was Laura Makray, worked in the Department of Labor, Office of Inspector General. The Office of Inspector General, or OIG, is a department that's responsible for the auditing that's done within the Department of Labor. And of course, the auditors are the folks who go over all government operations with a fine-tooth comb to root out waste, fraud, and abuse. Now, Laura was a GS-14, and her legal claim was that when she was not promoted to the GS-15 position, as the head of audit quality assurance, and instead a less qualified man was put in that position, that it constituted an act of gender discrimination. Our task on the jury was to determine whether in fact that was the case. Now, in his opening statement, the lawyer for the government, which was the defendant in this case, basically stipulated that Laura was a smart person, that she was knowledgeable, that she was technically skilled, basically that she knew her stuff. But, he said, there's more than simply technical expertise that goes into being the director of quality assurance. You have to, importantly, be able to manage people. And as he put it, you need tact. So what he promised us was that as the trial went on, we would discover that for all Laura's technical qualifications, she lacked the managerial ability and the people skills to be able to do this optimally. And that in fact, the person who did get the job, whose name was Melvin, surpassed her in this all-important category of tact and diplomacy. Well, as the trial went on, nothing could be further from the truth. Laura was shown to be an extremely well-regarded person within the division with more than adequate people skills, somebody who other auditors sought out for advice, for guidance, highly well-regarded, whereas her counterpart, Melvin, the guy who actually got the job, had very poor communication skills, which we saw for ourselves when he testified, and was held in relatively low regard by his colleagues. We also saw, as the trial went on, a series of women take the witness stand and each tell us about their negative experiences within the department. Each one of them felt mistreated and damaged in one way or other in their experience of this department. So by the time we reached the end of the testimony, which took 7 days, what we had discovered was that the original line of defense, that Laura lacked tact and diplomacy, had been shattered by the testimony we had seen. But the government lawyers had a fallback position. In his summation, the government lawyer reminded us that we were not there to second-guess the hiring decisions of the Department of Labor. After all, good and bad hiring decisions are made all the time. We were there to determine whether a violation of Title VII of the Civil Rights Act of '64 had taken place, whether Laura Makray's gender had been a determinative factor in her non-promotion in this case. And from the perspective, of course, of the government's lawyer, this had not been shown. There was no smoking gun. There were no emails saying, hey, let's keep women down. There was no explicit policy to in any way discriminate against women. The question was whether there was sufficient circumstantial evidence to determine that gender discrimination had taken place. So after a week of testimony, the case went to us, the jury, for deliberation. And it's important to point out two things about our weighing of the evidence. First of all, because this was a civil trial, there are only 8 jurors, not 12 as you would get in a criminal trial. Second of all, our standard of proof was far less than that of a criminal trial. Rather than having to find somebody guilty beyond a reasonable doubt, our job was to see whether somebody was liable by the preponderance of the evidence, which meant Based on the evidence, was it more likely or less likely that an act of gender discrimination had taken place? So when the jury was first polled, the count was 5 people, including myself, reaching a finding of gender discrimination. 5 of us felt that Laura had clearly been discriminated against, in part because of her gender. 3 members of the jury, all males, initially questioned whether the plaintiff had met her burden of proof. Now, to be sure, all 8 of us recognized that something had gone wrong in the hiring decision. This was a very dysfunctional office where a lot of toxic things were going on. The question that the men were raising was, yes, but did it reach the threshold of gender discrimination? As one of the jurors put it, very pungently, yes, Laura's boss was a dick, he said, but he seems to have been a dick toward everybody. Wasn't he sort of a equal opportunity jerk who discriminated against men as much as women? So with that original division of 5-3 in favor of Laura, we began to go more thoroughly through the evidence. And a couple of important things came up when we explored the evidence. First, we all came to understand that Laura had not only been turned down for this job, which was at issue, but there were also 2 previous jobs where she clearly seemed to be the most qualified person for those jobs and had gotten slighted for those jobs too. So we found evidence of 3 jobs where the government seemed to have bent over backwards not to give her a promotion. Second of all was the testimony of the women, the other women in the office. One woman had taken early retirement rather than stay a day longer in the office. And by taking early retirement, she was actually taking a loss of some of her pension benefits. But she simply wanted to get the hell out of there. A second woman transferred out at a lower grade level. She had come in as a GS-15 and hurriedly got out of there at a GS-14 level so she wouldn't have to work in that office anymore. That's almost unheard of. A third woman recounted her experience with Laura's boss, Michael, where Michael would not say hello to her in the hall. So all of that sort of added weight to Laura's claim. And the third leg of the stool was actually seeing the guy who actually got the job, Melvin. The difference between the two in terms of professionalism and qualifications and communication skills, everything that you would want in a good director in your organization, there was just a monumental difference between the two. So at the end of the day, we came to the decision that all of this evidence put together did rise to the level of gender discrimination. So having reached unanimity on that issue, it fell to us to determine what the damages would be. And this was all incredibly new to us, the guidelines for damages. So the guidelines for the monetary compensation that we were to give were very interesting. It wasn't our job to come up with an award based on lawyers' fees, lost salary, any of that. Those were technical damages to be determined by the judge at a later date. Our job was to come up with a kind of an existential award. What was the emotional suffering? What was the burden? What was the level of inconvenience? What was the loss in terms of seniority or other job opportunities that may have been lost along the way because of the non-promotion? And it's important to note that the case had taken 4 years to come to trial. That is, if she had been promoted, she would have been promoted not yesterday, but 4 years ago. So at that point, we all began to throw out recommendations for damages. And interestingly, they ranged from, on the low end, $1 suggested by one of the males, and $500,000 suggested by one of the females. Now, the male felt that because the plaintiffs had only barely met their burden of demonstrating gender discrimination, he felt that the award should be fairly minimal. The female on the jury felt that there had been an enormous loss, particularly when factored over 4 years, where she had been languishing at the same grade level for the last 4 years. She felt that the loss in terms of career advancement was tremendous. I threw out the number of $100,000, saying that I would never offer this plaintiff $1 because that would suggest that we on the jury felt that her injury was a trivial one. And I didn't feel it was trivial at all. I shared the woman's feeling that it was an enormous loss that she had suffered. She would have been in a managerial role. She would have had enormous responsibility. She had already shown a great deal of creativity in the lower position that she was in. Who knows what she might have done in the higher position, the director position. She also would have been a role model to other women in the department because there were no GS-15 women in the Department of Labor Office of Inspector General at that time. So I said, look, I'm throwing out $100,000. I'm willing to go higher, but I won't go lower than $100,000. So we all began to discuss it, debate it, and it was a very thoughtful, good, quality, collaborative discussion. And finally, we settled on the number of $200,000 as an award. And that became our decision. The judge, by the way, was Judge Beryl Howell, a female Obama appointee from 2010, who I thought had conducted the trial with a fair but firm hand. I liked the way the trial was run. So our foreman got up and said, Your Honor, we find for the plaintiff. And we find for the plaintiff in the amount of $200,000. Now, at that point, what happened was pretty remarkable for me. Laura Makray, who was a very disciplined, controlled, analytical, rational person, began to sob with joy and relief and with gratitude at having finally prevailed in this case after 4 years. And watching her sort of collapse at the plaintiff's table in tears of joy was so touching to me, just to observe this, that I must say I got a little bit misty myself watching it. And so that was it. That was our decision. Judge Howell came into our little jury room a little bit later and to thank us and debrief us. And I said to her, you know, Judge, frankly, none of us really wanted to be here, but it was a very enriching experience for us all by the end of the week. So while I have the floor, I just want to point out 2 interesting things that we found out about the Department of Labor. Now remember, we were looking at auditors who, you know, again, go over government operations rigorously to make sure that everything is going as it should. One of the things that we discovered about the hiring process within this department is that on your application for a job, you can lie up a storm, you can lie to a fare-thee-well, as long as the lies you tell on your application don't bear on the specific job requirements that you have. Let me give you an example. If I were applying for Laura's job, I would need an accounting degree. But if on my application I decide to pad it by saying, well, you know, I speak 24 languages, and in my spare time I got a PhD in astrophysics from MIT, those things go on my application and nobody fact checks them to see whether they're accurate. Why? Because you don't need those things for the job. So they will simply stay there on my record because I've gotten through the first level of screening. And those faux job credentials that I listed will follow me around for the rest of my career because nobody bothered to check them on the ground floor. The reason I bring it up is because the guy who did get the job, Melvin, lied on his application. He said that he had a master's degree in accounting, which he didn't have. He also said that he was a certified fraud examiner, which he wasn't. But nobody looked at those credentials because they weren't necessary for the job. But come on. I mean, clearly you've got to do a better job than that, Department of Labor. The second outrage that we discovered was the nature of the interview process in hiring. And perhaps I'm just out of it in terms of the way corporate and governmental America works. They used what they called a structured interview, in which 4 questions were drawn up. Same questions are given to each applicant, which is perfectly appropriate. And for each question, there was a specific number of elements or components that had to be covered in the answer for it to be judged a successful answer. So, person is asked a question, they need to cover, let's say, 5 things. And once they start talking and finish and then come up for air, there's no follow-up, there's no clarification. That stands as their response to the question. So for example, let's say I'm incredibly knowledgeable, and they ask me a question, and I cover items A, B, and C beautifully. I mean, I know my stuff completely. But in the stress of the moment, I kind of give short shrift to items D and E, 4 and 5. Nobody then says to me, hey Jeff, you really did a good job on 1, 2, and 3, but you don't seem to have much to say about 4 and 5. Do you have any experience or any understanding of those issues? Oh, of course I do. I've got a lot of things to say that just slipped my mind in the moment. Here, let me tell you what I know about 4 and 5. And then I go on for 10 more minutes, at which point the interview panel says to me, oh, well, thank you very much. You're a much more well-rounded candidate than we initially thought you were. So not only have they plumbed the full depths of my knowledge on that subject, but they've gotten to see how I interact interpersonally. So it's a win-win. And of course they do that for everybody. So at the end of the day, they're judging me at my best against my competitors for the job at their best, as opposed to the way it actually worked at the Department of Labor. They were giving people incredibly high-powered, important jobs, like director of the Office of Audit Quality Assurance, after an 8-minute interview. After an 8-minute, you couldn't get into a college with an 8-minute interview. You couldn't get into a law firm at the ground floor, an entry-level position with an 8-minute interview. The idea that the government is promoting people based on these bare-bones, skeletal interviews was just preposterous to me. Anyway, just wanted to rant a little bit. So in closing, I don't know whether Laura will ever get her award. I don't know whether the government will appeal tomorrow and tie her up in knots for the next 3 years. I don't know what's going to happen. Nor do I think that we managed to transform government as we know it. Our contribution was a little drop in a gigantic ocean. But we did what we could, and it was a very gratifying, satisfying experience. I'm Jeff Rowan. Thanks for watching.